You can stop 14 closings over one strip of dirt. That's what the HOA president told me after her developer finished 14 luxury cabins that could only be reached by crossing my hunting land. They had paved a road through my meadow, buried utilities across my ridge, taken deposits from 14 buyers, and scheduled every closing as if my property already belonged to them. There was just one problem: the easement they kept citing did exist. No signature from me, no recorded grant from my father, no legal access hidden inside some forgotten deed. Nothing. And I knew that because I had spent 34 years practicing real estate and property law, so I didn't yell, I didn't park a truck across the road, I didn't stand in front of bulldozers. I opened the county records, rebuilt my chain of title, started a file, and waited, because eventually 14 buyers, their lenders, and 4 title companies were all going to ask Heritage Development Partners the exact same question. How do you sell a cabin nobody can legally reach? My name is Raymond Aldrich. I am 61 years old, and for 34 years I practiced real estate and property law in Maine. I retired in 2021, not because I was tired of the law. Because my wife, Margaret, was gone. We had been married 29 years when pancreatic cancer took her. After that, Portland felt too crowded with memories. Every room had something of hers in it. A coffee mug, a watercolor brush, a sweater hanging on the back of a chair because neither of us had ever bothered to put it away. Every quiet morning somehow felt louder than the last. So I went north. My father had left me 212 acres of hunting land above Moosehead Lake, hardwood ridges, a narrow creek that froze hard every winter, an old timber camp my grandfather built with his own hands, and a lower meadow my family had been walking for generations. I had hunted that land since I was 9 years old. My father taught me where the deer crossed the meadow. My grandfather showed me which old stone walls marked the property lines. And Margaret loved that meadow. Whenever we visited, she would walk it near sunset with a thermos of coffee, watching the tree line for deer, so the land wasn't an investment to me. It was a development opportunity. It was family. 6 weeks after I moved back, I walked outside one morning and saw bright orange survey stakes cutting straight across the lower meadow. I had never authorized a survey. I took photographs before touching anything. I recorded the date, I logged the coordinates. Then I pulled every stake. Margaret used to tease me because I kept binders for everything. Tax records, deeds, correspondence, surveys, receipts, anything that might matter later. She called them my paper army. 3 days after I pulled those stakes, they came back. Only this time, a white pickup followed them up my private road. 2 men stepped out wearing polo shirts with a company logo I had never seen before, Heritage Development Partners. One of them smiled, pointed toward my ridge, and told me they were beginning work on a 14-cabin luxury development, fully permitted, fully approved, luxury hunting retreats, he called them. I looked at him and asked one question: "Show me the easement." His smile disappeared. He told me their legal team handled the access documents. He said somebody would call. Nobody did. So the next morning, I drove to the registry and pulled every document connected to the development. Heritage site plan was very specific. It showed a road easement across my lower meadow, a utility easement running along the ridge, and permanent access rights for every future cabin owner. All 3 referred to the same recorded instrument number. On paper, that should have ended the question. Except the number was wrong. I pulled the document myself. It wasn't an easement. It was an old boundary line agreement between 2 completely unrelated property owners from 1987. No Heritage Development Partners, no Ridgeland Reserve, no right to cross my land, no right to bury utilities, no right to promise future buyers permanent access, so I checked the grantor index. Then the grantee index, then every deed in my chain of title going back more than a century. Nothing. There had never been a recorded easement across that meadow, not from me. Not from my father, not from my grandfather. Heritage hadn't merely overlooked a page. They had built their entire access plan around something that did not exist. I sat in the registry parking lot for almost 20 minutes before driving home. Not because I was confused, because I understood exactly how serious the problem was. A cabin can be beautiful. It can have granite countertops, cedar siding, a stone fireplace, and $1 million view. But if a buyer cannot establish a legal right to reach it, that access problem can swallow everything else. That afternoon, I opened a new binder, tab 1. My chain of title. Tab 2. Heritage S Development Documents. Tab 3. The instrument number they claimed was their easement and the completely unrelated document it actually belonged to. I could have sent a cease and desist letter that afternoon. I could have gone straight to court. Instead, I made copies. Then I waited because Heritage was still pouring concrete. And every dollar they spent made the missing easement more important. About a week later, a white SUV came up my road. The woman behind the wheel introduced herself as Diane Coulton, president of the newly formed Ridgeline Reserve Community Association. She carried a clipboard, 3 laminated badges, and the kind of confidence people develop when nobody has challenged them in a very long time. She told me the association would be managing the development's common areas. Then she casually included portions of the lower meadow in that description. My lower meadow, I asked her the same thing I had asked Heritage. Show me the deed. She gave me a tight little smile and said their legal team had already handled everything. Then she told me to stop removing survey markers and interfering with authorized construction. I didn't argue. I wrote down the time, photographed her vehicle, recorded what she said, and added another tab to the binder. A few days later, a certified letter arrived accusing me of obstructing a lawful development project. It cited the same easement number I had already proven, belonged to an unrelated document. That was when I stopped believing. This was simple confusion. They knew there was a problem. And instead of checking the record, they were choosing to repeat the claim. Then Diane escalated. New stakes appeared inside my tree line. A contractor showed up and started taking measurements without my permission. Then Diane called the sheriff's department and reported that I was harassing workers and trespassing around the construction site. Trespassing on land with my name on the deed. A deputy came to my house that afternoon. I invited him inside. Then I put the binder on the kitchen table. My deed, the full chain of title, the county record, the document Heritage claimed was its easement. And the registry record showing that document had nothing to do with my property. The deputy went through the pages twice. Then he looked at me. "Sir," he said carefully, "you may want to speak with an attorney." I nodded. "I am an attorney." He stared at me for a second. Then he closed the binder. The complaint was marked unfounded. Diane had tried to turn me into the trespasser on my own property. Instead, she had helped create the first official record documenting exactly who owned it. And Heritage kept building. Most people assume that once I confirmed there was no easement. I tried to stop construction. I didn't watch them finish the road. I watched excavators cut through the lower meadow. I watched utility crews trench along the ridge. I photographed every truck. Every trench, every new foundation, every time one of their crews crossed my property. I added the date, photographs, and location to the file. 14 concrete pads appeared first. Then framing, then roofs, cedar siding, stone chimneys, wide porches facing the mountains. Heritage was building fast. Diane started behaving as though the ridge already belonged to her community. Ridgeline reserve signs appeared. Marketing banners went up near the entrance. Contractors drove across my property without asking, because by then, everyone working on the project had apparently been told the same thing. The access was legal. One of my friends asked why I didn't park my truck across the road and force the issue. The answer was simple. Stopping construction would have created a fight over dirt. I wasn't interested in dirt. I was interested in title. Developers can fight trespass claims. They can hire attorneys, file motions, seek temporary orders, delay, negotiate, keep construction moving while everyone argues. But eventually, Heritage had to sell those cabins, and buyers don't just purchase walls and roofs. They purchase legal rights. A mortgage lender wants marketable, insurable title. A title company wants documented access. And a buyer spending hundreds of thousands of dollars wants to know that somebody cannot wake up one morning, close a gate, and lawfully cut them off from the house they just bought. Heritage had a paved road. They had utilities. They had 14 expensive cabins. They had glossy brochures, but they still didn't have my signature, so I stayed quiet. I let Diane keep smiling for photographs. I let Heritage keep spending, and I kept building the paper trail. By the time the 14th cabin was nearly complete, I knew exactly what had to happen next. I needed Heritage to do the one thing that would turn its missing easement from a property dispute into a financial disaster. I needed them to find buyers. The first sales banner went up on a Friday. Ridgeline Reserve Luxury Hunting Retreats. Starting prices were over $400,000. Within weeks, Heritage had buyers lined up for all 14 cabins. Couples arrived on weekends carrying brochures and coffee cups. They walked the porches, took photographs of the mountain views, asked about fireplaces and floor plans. Sales agents talked about privacy, security, permanent access, a private community tucked into the Maine woods. Every time I heard the phrase permanent access, I looked at the road crossing my meadow. That was the one thing Heritage could not legally promise. Then deposits started coming in. Closing dates were scheduled. Mortgage lenders ordered title work, and suddenly the stakes changed. Until that point, Heritage could still characterize the situation as a dispute with one stubborn landowner. Now 14 families were preparing to hand over hundreds of thousands of dollars for cabins whose only practical access crossed property Heritage did not control. That bothered me more than the bulldozers. Those buyers had not driven heavy equipment through Margaret's meadow. They hadn't sent me threatening letters. They hadn't called the sheriff. Most of them had no idea there was even a dispute. So I started looking harder at Heritage, old projects, court records, property filings, previous disputes, and I found enough title problems surrounding earlier developments to make me stop believing. This was simply careless paperwork. Maybe they had become comfortable moving fast. Maybe they assumed rural landowners would check. Maybe they believed that once enough money was invested, the owner would eventually sign whatever agreement was placed in front of him. Whatever the explanation, I knew one thing. I was not going to let 14 families discover the problem after they owned the cabins. That evening, I spread everything across my dining table. My deed, the chain of title, the registry record, the phantom easement number, photographs of the road, photographs of the utility work, the development map. Then I made 4 identical sets. Not for Diane, not for Heritage, for the companies that would decide whether those 14 transactions could actually close, the title insurers. By Monday morning, all 4 packages were in the mail. The first response didn't come from a title company. It came from Heritage. 3 days later, a black SUV pulled into my driveway. This time, it was to Deanne. One of Heritage's managing partners stepped out with an attorney I recognized from the certified letters. They were polite, very polite, that told me more than shouting would have. The attorney said everyone wanted to avoid what he called unnecessary complications. Then he placed a proposed easement agreement on my kitchen table. Heritage would pay me for permanent road and utility access. All I had to do was sign. 4 months earlier, they had behaved as though my permission didn't matter. Now they were willing to pay serious money for it. I read the agreement once. Then I slid it back across the table. No! The managing partner stared at me. Then he asked what number I wanted. I told him he misunderstood. This wasn't about finding a larger number. They had crossed my land without permission, buried utilities, threatened me with attorneys, sent an HOA president to claim my meadow, called the sheriff when I refused to cooperate. And now 14 buyers were depending on the exact same access Heritage had never bothered to secure. I wasn't going to quietly repair the problem so they could pretend none of it had happened. The attorney's tone changed. He warned me that interfering with pending transactions could expose me to damages, so I opened the binder. I showed him the deed, the registry record, the false instrument number, the photographs. Then I showed him copies of the 4 evidence packages I had already mailed. For the first time, neither man said anything. Heritage finally understood the position it had put itself in. They could argue with me, they could challenge me in court, they could have Diane send another letter, but they could not order a title insurer to ignore a defect in legal access. Before leaving, the attorney asked one final question. Have any of them responded yet? I told him the truth. Not yet. He looked relieved. I was because the next afternoon, a certified envelope arrived. The first title company had completed its review. I carried the envelope to the kitchen table. Margaret's old coffee mug was still sitting on the shelf beside me. I opened the letter and read the first paragraph twice. They were declining to ensure the promised access. That first refusal changed the tone immediately. Heritage stopped sending threats. Now they were making phone calls. Their attorney wanted to know exactly what I had told the title company. I told him I hadn't told them anything that wasn't already sitting in public records. 2 days later, the second response arrived, declined. Different company, same problem, no recorded easement establishing legal access across my property. Heritage postponed several closings and told buyers it was a routine title delay. Diane apparently called it a paperwork issue. Then the third company answered. Another refusal. This one went further. Their review department requested more information about the instrument number Heritage had used to support its claimed easement. That was when the panic became visible. Sales agents stopped bringing buyers up the road. Contractors disappeared. The Ridgeline Reserve office stayed dark for 2 straight days. But 2 cabin transactions were still connected to the final underwriter. Heritage only needed one company willing to accept their theory. One approval might have given their attorneys something to work with. So everyone waited. The fourth envelope arrived on a Thursday morning. I opened it at the same kitchen table where Heritage had tried to buy my signature. The answer was 3 pages long. I only needed the first one, declined. I sat there for a moment and looked through the window toward the ridge. 4 title underwriters, 4 refusals, 14 completed luxury cabins. And not one clean closing. The buyers couldn't get ordinary title coverage on the access Heritage had promised. Their lenders weren't going to simply pretend the problem didn't exist. Heritage had spent months building houses, but they had never secured the legal right that made those houses reachable. One missing easement had frozen every single closing. The first closing had been scheduled for Monday morning. It never happened. Neither did the second or the third. By lunchtime, buyers were calling Heritage demanding answers. Mortgage lenders wanted clarification. Attorneys wanted copies of the access documents. And every conversation eventually returned to the same question. Where was the recorded easement? Heritage kept calling it a temporary title issue. Diane told residents there was nothing to worry about. One buyer drove to my property himself. He was a man in his 50s who had put a substantial deposit on one of the larger cabins. He stood beside the road looking from the pavement to my meadow. "Are you telling me," he asked, "that the only road to the cabin crosses your land?" "Yes, and Heritage doesn't have an easement. Not one I've ever signed, inherited, or found in the county records." His face changed. "So I am buying a house I may not have a legal right to drive to." I didn't answer. I didn't need to. By the end of that week, every scheduled closing had been postponed. Buyers started hiring their own attorneys. Heritage phones were ringing constantly, and somehow Diane still refused to cancel Ridgeline Reserve's grand opening. She had already ordered the banners. Invited a local reporter. The HOA board planned to stand behind her while she introduced Ridgeline Reserve as the region's newest luxury community. Apparently, she thought confidence could outrun paperwork. I almost stayed home. Then I heard what she planned to tell the buyers, that every access and title issue had been resolved. That was different. So on the morning of the grand opening, I put the 4 title company letters into my binder. Then I added the deed, the chain of title, the registry record, and the document Heritage kept calling an easement. Diane wanted an audience. For once, so did I. Ridgeline Reserve looked impressive that morning. Fresh gravel, new signs. 14 cedar cabins lined along the ridge like somebody had cut them out of a real estate brochure. Heritage had set up a white tent near the entrance. Coffee tables, folding chairs, a banner that read, "Welcome to Ridgeline Reserve." Diane stood beside a podium in a navy blazer, greeting buyers as though nothing was wrong. The Heritage partners stayed near the back. Their attorney was there too. He noticed me before Diane did. His expression told me he knew exactly what was inside my binder. A local reporter started filming. Diane stepped to the microphone. She thanked Heritage. She thanked the HOA board. She thanked the future homeowners. Then, she told the crowd there had been some minor administrative confusion involving access documents. She smiled. "All title matters have now been resolved." That was the sentence I had come for. I stood up. Diane stopped talking. "I am sorry," she said. "This is a private community event." "No," I said calmly. "It's a sales event for 14 cabins whose only access crosses my property." Nobody moved. I walked to the front and set the binder on the table beside the podium. The reporter turned her camera toward me. Diane told me to leave. I opened the binder. "This is my deed." I placed the first document on the table. "This is the chain of title for the land underneath your access road." I placed another document beside it. "This is the instrument Heritage has been calling an easement." Then I held up the registry record. "It is T1. A few buyers started whispering. The heritage attorney stepped forward. Mr. Aldrich, I kept going. These are the 4 title company decisions issued after they reviewed the access records. I placed the letters on the table one at a time. Declined, 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 declined. The room went silent. One buyer stood up. Are our closings canceled? Heritage's managing partner started saying the company was working through a technical matter. I shook my head. There is no recorded easement across my land. Then I looked at the buyers. And as of this morning, not one cabin in this development has insurable legal access through my property. That was when the questions exploded. People wanted to know what happened to their deposits. One buyer demanded to know why Heritage had advertised permanent access. Another asked Diane why she had just told everyone the problem had been resolved. The reporter moved closer. Diane tried to regain control. She said the HOA had authority over the road. I slid my deed toward her. Then show everyone where your authority begins. She looked at the page. She didn't answer. For months, she had used titles, letters, police complaints, and a clipboard to make ownership sound negotiable. Now there were 14 completed cabins behind her. 4 title refusals sitting on the table, and a camera recording every second. The grand opening lasted less than 20 minutes. By that afternoon, buyers were calling attorneys. Heritage was fielding demands for answers, and the story was already spreading through the county. But the call that truly ended the development did come from a buyer. It came from Heritage's lender. Once the lender learned that all 14 closings had been frozen and the project had no insured legal access across my property, they began reviewing the construction loan. That review did not go well. Without the sales, Heritage could not bring in the money it had expected. Without clean access, they could simply find 14 replacement buyers and pretend nothing had happened. The project was suddenly carrying completed construction, unpaid obligations, angry purchasers, and an access problem that existed in the public record. Within days, the development was in serious financial trouble. The buyers hired attorneys. Deposits were challenged. Investors started asking questions. Heritage could no longer answer with glossy brochures and promises. And Diane? She stopped driving up my road. The Ridgeline Reserve signs came down not long after. The community association that had spent months telling me what I could do on my own land suddenly had very little community left to manage. I could have enjoyed that, maybe part of me did, but a few weeks later I stood alone in the lower meadow and realized I didn't feel like celebrating someone else's collapse. I thought about Margaret. About the evenings she used to walk that field, about my father teaching me the property lines, about my grandfather building the old camp before anyone had ever heard the words Ridgeline Reserve. The point was never to destroy 14 cabins. It was to stop somebody else from deciding that ownership was optional because they had more money, more signs, and a louder voice. So I did something better than revenge. I kept the land, and afterward I started working with neighbors and local attorneys to help rural property owners understand their deeds. Easements and boundaries before someone convinced them that paperwork didn't matter, because paperwork does matter, especially when somebody is counting on you not reading it. And I kept the binder. It still sits on the shelf in my study. The deed, the photographs, the certified letters, the development maps, 4 title company refusals. Margaret used to call my binders my paper army. She was right. It never fired a shot. I never had to threaten anyone. I never had to tear down a cabin. I never had to stand in front of a bulldozer. All I had to do was keep the records. Know where the property line was, and wait for Heritage to reach the one moment when the truth mattered more than everything they had built. Closing day, 14 luxury cabins. 14 frozen closings, 1 missing easement, and 212 acres that were still mine.